Right, so the concept of the core of Indianness and how its changing contours determine which activities are subject to federal labor regulation. In this particular paper, we're focusing on employment in the context of First Nations band councils. Band councils are governance structures created by the Indian Act, legislation passed by the Canadian federal government, Parliament in 1876, and still enforced today with amendments. Land councils are the government recognized by the Canadian state on First Nations reserves, which are land set aside for the use of First Nations people, that is, Indigenous people other than Inuit and Métis. The Indian Act allows First Nations to elect chief and council, either using a process set out under the Act or using a custom elections code approved by the Minister of Indigenous Services. Band councils are authorized to enact bylaws on behalf of the reserve. These bylaws are divided into two broad categories: general bylaws, like those relating to public health, traffic regulation, land allocation, and building permits, and money bylaws, like those relating to taxation and business licensing. Band councils generally employ staff to engage in a range of administrative duties, and they generally tend to be small enterprises with fewer than 20 employees. Notably, band council employees are federally regulated, not because their work touches on the core of Indianness, but because band councils themselves are products of the Indian Act, a piece of federal legislation. Indeed, as a form of governance, band councils don't typically reflect Indigenous peoples' traditional practices. Rather, they were instituted by colonizing governments as a means of displacing existing Indigenous governance practices. In the context of Canada's larger governance system, band councils are often framed as being akin to municipal level governments with similar responsibilities and powers. As a colonizing practice, this framing actively closes off the possibility of establishing a nation-to-nation relationship between Indigenous nations and the Canadian state. Next slide. The legal precedent for the federal regulation of employment by band councils was established via a series of cases which began as a union certification case, Francis v. Public Service Alliance of Canada. In 1972, the Public Service Alliance of Canada was certified as the bargaining unit for all employees of the Iroquois of St. Regis Band Council in Cornwall, Ontario, excluding the band administrator, the secretary to the band administrator, constables, and summer casuals. The undertakings of the band spanned two provinces, Quebec and Ontario. The union certification was not contested by the band council, but they did not engage in bargaining. So the Canada Labour Relations Board ordered the band council to engage in collective good faith bargaining with the union in order to establish a first contract. This led the band council to file, under the name of Chief Lawrence Francis, to rescind the union certification on two bases. First, that the CLRB lacked jurisdiction to deal with the employment of Indian persons on reserve, and second, that the band council, as a group of elected officials, is not a person or an employer within the meaning of the Canada Labour Code, and that the employer is actually the band itself. On appeal, the certification of the bargaining unit was overturned, not on jurisdictional grounds, but on the basis that the band council is not the employer. In the decision in the Francis case, Justice Heald applied the two-part functional test established in 4B, as previously discussed in the previous papers, to the bargaining unit. In the first part of the test, concerning the primary focus or activities of the enterprise to determine if they normally fall within provincial jurisdiction, Justice Heald concludes that the function of the band is governmental in nature, and that the administration of the band is continuously concerned with the status and rights and privileges of the band Indians, and thus its labor relations are an integral part of primary federal jurisdiction over Indians or land reserved for the Indians, as set out in Section 9124 of the Constitution Act, 1867. In the second part of the test, concerning whether or not the field is currently occupied by the federal head of power, Justice Heald determines that it is, since band council administration constitutes a work, undertaking, or business that falls within the meaning of the Canada Labour Code. In 1982, the Supreme Court ultimately determines that the St. Regis Band Council, and implicitly all band councils, can be considered employers, but does not engage with the jurisdictional arguments set out by the lower courts. So as we've already heard, the two-part functional test established in the 4B case was fundamentally reshaped by the 2010 Supreme Court ruling in Nil 2 Child and Family Services Society versus the BC Government and Service Employees Union. It narrowed the scope of labor and activities that were regulated under Section 9124 of the Constitution Act, determining that only aspects of, quote, Indianness that warrant federal exclusivity were subject to federal regulation. So that the case set out a clear demarcation between the activities of a work, undertaking, or business on one hand, and the people over whom those activities are performed on the other. determining that the provision of child welfare services was provincially regulated regardless of the Indigenous identity of the children and clients who received those services. Following the NIL 2.0 decision, the federal regulation of band council employees was once again put to the test in the 2015 case of Muncie, Delaware versus Fluelling. In this case, Crystal Fluelling, an accountant, argued that she was unjustly dismissed by the Muncie, Delaware First Nation. The adjudicator in the case determined that there was nothing unique about Fluelling's accounting activities, nor the habitual activities of the band council more generally, specifically the governmental activities of managing policing, welfare, health, and education, to make it federally regulated. The federal court overturned the adjudicator's decision, determining that the precedent set in Francis is still good law, even post NIL 2.0. This is because band councils derive their authority directly from the Indian Act, and the scope of their activities is governed by the Indian Act. Thus, because the Indian Act is a piece of federal legislation, employment by band councils must be federally regulated. Next slide. I might have missed a next slide previously, sorry. We're currently on the slide, implications for the court.
No problem, I'm following you.
Okay, cool. Okay, cool. Yes, sorry about that. In the previous paper, we heard how the, quote, core of Indianness has become narrowed, such that social welfare provisioning is considered provincially regulated despite its centrality to Indigenous cultural reproduction. Despite the work of band councils to ensure the health and welfare of their communities, it's not these activities that result in the federal regulation of band council employment, nor do cases establishing federal jurisdiction over band councils generally appeal to the, quote, Indianness of the activities that councils engage in. Instead, much like in the final three cases discussed in the previous paper, band council employment remains subject to federal jurisdiction not because its activities are concerned with Indigenous status and rights, but because the very existence of band councils as a form of governance is set out by the Federal Indian Act, much like the very existence of municipalities as legal entities are set out by provincial legislation. As is often framed, band councils are creatures of the Indian Act, that is, they only exist because of this legislation. It's this system of governance, which was explicitly designed to disrupt traditional First Nations governance practices, which is implicitly positioned within the core of Indianness as is envisioned by the settler state. Out of all the different types of work that takes place on reserve or under its jurisdiction, direct employment by the band council is most consistently treated as federally regulated. Given that the chief and council system is envisioned and structured by the Indian Act, it's central to how the Canadian state positions and regulates, quote, Indian identity and governance through a colonial lens in a way that's separate and distinct from Indigenous identities and governance practices. Not surprisingly, next slide, contestations around federal jurisdiction occur when the band councils broaden the scope of their activities or are not the direct employers. This is highlighted in the 2013 unjust dismissal case of Fox Lake Cree v. Anderson. Mr. Anderson, the complainant, was employed by the Fox Lake Cree First Nation Negotiations Office, which was responsible for negotiating contracts between Fox Lake Cree First Nation and Manitoba Hydro with respect to several hydroelectric projects in the area, primarily the Kiosk project around the Gull Rapids. The negotiations office was physically located off reserve, but it was considered an internal consulting office, and Mr. Anderson was employed directly by the band council, so the negotiations office wasn't incorporated as a separate entity. Mr. Anderson was terminated from his position in the negotiations office and filed a complaint on the basis of unjust dismissal as well as unpaid overtime and general holiday pay. A federal inspector ordered the band to pay, which they appealed. As discussed in the previous paper, in NIL 2.0, the Supreme Court repurposed the two-step test from 4B. First, the functional test is applied, and they ask, does the nature, operations, and habitual activities of the entity make it a federal undertaking? Next, if the functional test is inconclusive, they consider whether provincial regulation of the entity's labor relations would impair the core of the federal head of power. In Fox Lake, the original adjudicator finds that the work is federally regulated based on the functional test, since the beneficiaries of the activity are members of the band, and the negotiations office negotiate agreements on behalf of the band and for the benefit of all of its members. The original adjudicator also found that even if the function test was inconclusive, the provincial regulation of the negotiation office's labor relations would impair the core of the federal power with respect to the federal responsibility for First Nations and reserves. The Fox Lake Cree First Nation challenged this ruling, arguing instead that it's a provincial undertaking. Next slide. The federal court overturned the original adjudicator's decision on both fronts. On the functional test, the court found that the negotiations office, doing negotiation for the purpose of benefiting the band, is not relevant under the nil-to-will functional test, which does not take into account the purpose or beneficiaries of the activities. The projects under negotiation were all located within the province of Manitoba and thus provincially bounded. For the federal court, the need to consider Indigenous treaty rights in the negotiated contracts was not sufficient to put this work within federal jurisdiction. On the head of power test, next slide, the court finds the provincial jurisdiction over the labor rights of the negotiations office would not impair the core of federal power, for a few reasons. The negotiations office negotiated terms of agreements, but wasn't responsible for signing off on major decisions concerning the contracts. So the final sign-off on the contracts that were negotiated was up to the chief and council. And so the ruling says once you compartmentalize the chief and council from the role of the employees working in the negotiations office, then the scope of the negotiations office work couldn't impair the exercise of Aboriginal and treaty rights because they couldn't bind the nation to the terms of the agreements. They only worked out the terms. And they say to the extent that the negotiations office work does deal with the exercise of Aboriginal and treaty rights, there was insufficient evidence in their view that provincial jurisdiction over labor would impair those activities. In particular, the Indian Act does not identify negotiations regarding treaty rights or natural resources as part of the governmental activities assigned to band councils. It's not within the scope of bylaws that the band council is specifically empowered to enact. One of the initial responsibilities of the Fox Lake Cree Negotiations Office was to negotiate an impact settlement agreement with Manitoba Hydro, addressing the adverse effects of past hydroelectric development on the community. This can be conceptualized as being part of the governance responsibilities of band councils. But in the context of the court's decision in the Fox Lake Cree case, federal jurisdiction is narrowed so that when band councils engage in activities focused on the well-being of their communities, that is, they engage in self-advocacy, their work is considered to be outside of federal jurisdiction and outside the purview of the Indian Act. Negotiations around the implementation and effects of hydroelectric projects supposedly don't cut to the heart of Indianness. That is, there's no recognition that the diversion of waters, land, and natural resources might affect the centrality of Indigenous life and livelihood. The approach by the court in the Fox Lake case is consistent with the continued narrowing of the core of Indianness that the federal government regulates, and an increased emphasis on the Indian Act as the reason that band council activities are federally regulated, as opposed to the work being related to the core. Next slide. Many workers filing complaints under the Federal Canada Labour Code, rather than under provincial labour statutes, are doing so on the basis of unjust dismissal, a protection afforded by the Canada Labour Code, but not necessarily by provincial labour law. Unjust dismissal claims are particularly prevalent at First Nations band council employers as compared to other employers. In an analysis of labour standard complaints filed with the Federal Labour Program between 2001 to 2018 that we analyzed, we found that roughly 45% of complaints at First Nations band council employers were for unjust dismissal, the second highest proportion of any sector, second only to banking, which also has a disproportionate number of unjust dismissal cases. Federal labor inspectors that our teams interviewed have suggested that unjust dismissal complaints tend to be clustered after band council elections, when existing staff are replaced with new staff. And next slide. As well, the continued narrowing of the jurisdictional landscape has led to confusion among federal labor inspectors who we interviewed, many of whom were aware of nil-to-will and the concept of the core of Indianness, but whose descriptions of which employees would be regulated federally and which provincially were typically quite vague. This uncertainty also impacts potential complainants who, when filing a complaint, may not be able to get concrete answers about which laws apply to their particular situation. Next slide. So, band councils are a colonial structure that was used to displace existing Indigenous governance practices. But the work of band councils and the administrative structure and labor that supports them is positioned within the core of Indianness as envisioned by the settler state. But the persistent narrowing of the core of Indianness by the courts continues to reduce the extent to which even direct band council employment is considered to be federally regulated, especially in cases where band councils engage in activities that support the material and cultural well-being of band members in a way not envisioned by the Indian Act, and especially activities associated with asserting Indigenous treaty rights and stewardship over natural resources. In the next steps of this project, we'll turn our attention to a consideration of cases dealing with on-reserve gas stations operated by band councils or arm's length corporations controlled by band councils. And these cases introduce further complications with respect to federal jurisdiction, since gas stations also often serve as community hubs, and are a mechanism for ensuring community members can access resources like food, fuel, and transportation, as well as to make tax-free purchases. But an uncomplicated conceptualization of gas stations as private corporate entities disrupts these practices and further complicates the jurisdictional questions.